The exclusionary rule over the last decade and a half has been weakened in a series of cases, starting with Hudson, moving to Herring and Davis, and now Utah v. Strieff. We've seen a Supreme Court willing to change the understanding of when evidence is excluded based on a constitutional violation. It has evolved as a doctrine to excuse a lot more police behavior. If you take the Supreme Court's Herring decision at its word, we now will only exclude if the police officer's actions were deliberate or reckless or essentially so offensive that we are trying to deter the police officer's actions. And that was not always the way, but if you take that as serious, it means that many cases where evidence would have been excluded would no longer be excluded. Utah v. Strieff is another example where it's a situation where the police, admittedly, based on the testimony that came in, stopped a man without reasonable suspicion or probable cause. Turned out he had a warrant, the gentleman stopped, and so he was arrested, and incident to arrest they found illegal contraband. And the question was whether this unlawful stop with a valid warrant, which the officer didn't know about, should justify exclusion of the evidence. The court said no. The court said essentially the finding of the warrant was attenuated, removed the violation. And that's a strong, perhaps perhaps weak interpretation of the exclusionary rule, Justice Thomas writing, in a way that really redefines what exclusion means. And so I think as you look forward, you've seen a trend of weakening, almost to the point of, if you take the court's doctrine seriously, there should be far fewer cases where evidence would ever get excluded. I'm not sure that's necessarily the right vision, but it's definitely the way it has been going, and something to keep an eye out in the future to determine if we really do have an exclusionary rule to uphold principles of the Constitution in the future.